Hi, good morning. This is Gary DeWaal for Bridging the Week, October 14th to 18th, and today is October 21st. Last week, both the U.S. Commodity Futures Trading Commission and the U.S. Securities and Exchange Commission filed and settled widely publicized cases against industry giants for breakdowns in certain of their risk management practices. However, in doing so, the agencies endeavored to provide an itinerary of expectations of what other industry participants should do to stay out of the same or greater trouble. One matter, involving JP Morgan Chase Bank, the CFTC gave guidance on what specific new risk management requirements for swap dealers and major swap participants, if followed by the bank, might have kept it out of trouble in connection with its London whale episode, although the bank was not charged with violating these provisions. While the other matter, involving Knight Capital Americas, the SEC provided specific guidance regarding what provisions of its relatively new market access rule the firm should have complied with better in managing the technology supporting its automated order routing system. At the same time these legal actions were being publicized in the United States, the UK Financial Conduct Authority announced new procedures that could result in recipients of so-called Disciplinary Warning Notices, the UK equivalent of US Wells notices, being publicized by name by the FCA prior to the time a definitive decision is taken by the FCA to commence an enforcement proceeding following an investigation, let alone before an enforcement proceeding actually is filed. Wait, didn't the Magna Carta, which gave birth to the idea of due process, come from the United Kingdom? How principles change over time. Sad. Well, we obviously have a lot to cover this week, so let's get started. On October 16th, the Commodity Futures Trading Commission filed and settled a complaint for a fine of $100 million against JP Morgan Chase Bank for employing a so-called manipulative device at the end of February 2012 in connection with the bank's trading of certain credit default swaps. This trading was part of the bank's so-called London whale activity that previously had resulted in a loss to the bank of over $5.8 billion. In bringing this action, the CFTC relied on its new anti-manipulation authority under Dodd Frank and a recently adopted CFTC regulation implementing this provision. These provisions eliminate the CFTC's former obligation to prove intent to prosecute successfully a manipulation allegation. As part of its settlement, JP Morgan admitted certain factual allegations made by the Commission relate to the underlying conduct at issue. In general, the CFTC claimed that, in order to reduce mark-to-market losses in a very large proprietary portfolio that included credit default swaps, JP Morgan sold on February 29, 2012, quote, a staggering record-setting volume, end of quote, of one specific credit default index. Coupled with trading the prior 2 days, quote, the quantity sold by JP Morgan amounted to roughly one-third the volume traded for the entire month of February by all other market participants, end of quote. This large amount of trading, says the CFTC, constituted a, quote, manipulative device in connection with swaps, end of quote, and was a violation of law because it was done recklessly. What is unique in the CFTC's order is the extensive discussion of Commission rules adopted after the conduct at issue, mainly the risk management rules related to swap dealers and major swap participants, and how, had they been in effect during the relevant time, they may have impacted and perhaps prevented JP Morgan's conduct. Indeed, in a somewhat unusual, gratuitous self-promotion in an enforcement action, the CFTC even went so far to say that had JP Morgan been following the CFTC's new rules, which it was not required to do so in early 2012, it might have avoided its large losses. Well, talk about crystal ball retroactive fortune telling. Also on October 16th, Knight Capital Americas agreed to pay a fine of $12 million to settle a complaint filed by the Securities and Exchange Commission related to the breakdown of Knight's automated routing system for equity orders that led to an unanticipated over 4 million executions in 154 stocks for more than 397 million shares on August 1st, 2012, and a loss to Knight of over $460 million US. Wow. As part of its settlement, Knight also agreed to retain a consultant to review its risk management controls and supervisory procedures and its software development lifecycle processes. In connection with this matter, the SEC charged Knight with violating its relatively new market access rule adopted in 2010, which became effective during 2011. Generally, says the SEC, this rule requires, quote, a broker-dealer to have systematic financial risk management controls and supervisory procedures that are reasonably designed to prevent the entry of erroneous orders and orders that exceed preset credit and capital thresholds for each customer and the broker or dealer, end of quote. The SEC also charged Knight Capital with violating certain of its requirements related to the handling of sell orders, so-called SEC Regulation SHO, SHO. Beginning on no later than July 14, 2011, ironically the effective date of its new market access rule, and continuing through at least August 1, 2012, says the SEC, quote, Knight's system of risk management controls and supervisory procedures was not reasonably designed to manage the risk of its market access, end of quote. As explained by the SEC prior to August 1st, Knight modified software code to support its order routing system in light of a new program at the New York Stock Exchange. In doing so, Knight moved its new code to 7 of 8 servers hosting its order routing system, but failed to move its new code to one of the servers. As a result, orders sent on August 1st to this one server triggered an old, unrelated program that generated a very large quantity of unanticipated orders. When Knight's technology staff worked to identify and resolve the issue, Knight remained connected to the markets and did not stop sending the unanticipated orders, which continued unabated. Technology is very helpful until it goes wrong. Last week, the UK Financial Conduct Authority announced that, effective immediately, it may publicize information regarding warning notices issued to potential subjects of FCA disciplinary actions prior to an enforcement action actually being taken, let alone being definitively authorized. The FCA issues disciplinary warning notices, somewhat akin to so-called Wells notices in the US, when it proposes to take action against a respondent, potentially resulting in a censure, fine, suspension, or restriction. Previously, FCA published information regarding enforcement actions only after it had decided to take an enforcement action. If subsequent to publishing a warning notice statement, FCA determines not to take disciplinary action against the firm or individual, the regulatory agency will not remove the information on its website regarding such warning notice. Instead, it will solely indicate that the subject of the warning notice has been discontinued. To me, this seems like a terribly unfair rule. Many times when a firm loses its reputation, it suffers a far greater cost than a regulatory fine. If the FCA can ruin a firm's reputation prior to even commencing an enforcement action, something seems terribly unjust. I covered this matter in detail in a special article on my website. Check it out. And finally, 2 articles. One, the CFTC resumed operations on October 17th and immediately issued 3 more Dodd Frank related no-action letters. 2 letters granted authority to multilateral trading platforms, one trading FX products and the other interest rate swaps, to continue operations, including transactions with U.S. persons, without being registered as swap execution facilities through November 19th. The third granted no action to certain non-U.S. persons to continue not to include in their de minimis calculation, for purposes of the CFTC swap dealer definition, swap transactions with guaranteed affiliates of certain U.S. persons registered as swap dealers who themselves are required to register as swap dealers independently. And the CFTC also announced on late October 18th that it is seeking public comments on a certification by Javelin SEF to implement a made available to trade determination regarding certain interest rate swaps. If this certification is permitted, all transactions involving the relevant swaps must be executed on a designated contract market or swap execution facility in accordance with applicable rules. Obviously, Javelin is trying to be first in to set the standard. Well, that's it for this week's Bridging the Week. Until next week, this is Gary DeWall. Have a great week.